I'm questioning a witness in a medical malpractice case, and all of a sudden the judge stops me and takes over the questioning. What can I do as the attorney who's cross-examining a particular witness when the judge takes over questioning? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. The reality is that when I'm questioning a witness on cross-examination, I have a series of goals that I have to achieve. And I have a certain agenda in my mind about what I need to ask this particular witness in order to achieve those goals. Now, if the judge interrupts me and now takes over the questioning, he's doing a number of things. He's trying to get information that he thinks that I'm not bringing out of this particular witness. Or he's trying to find out information from this particular witness that I have not established. One of the things that does is that it takes away from me the ability to question the witness in the way that I feel is appropriate. Now, if I object to the judge doing that, what do you think is going to happen? Objection, Your Honor. Your Honor can't question this particular witness. Objection to the question, Your Honor. What do you think that makes me look like? Who's in charge of the courtroom? Me or the judge? You know the answer, of course, right? The judge is in charge of the courtroom. And if he wants to go ahead and question a particular witness, for whatever reason, he's going to be able to do that. Now, I can raise whatever objection I feel is necessary, and I probably will. Why? Because I don't want the judge taking away my function, and I don't want the judge asking certain questions that I think are not appropriate. So what can I do about it? The only thing I can do about it is make an objection as politely as possible. And then what that means is that I'm preserving my objection for an appeal. So that means if, for some reason, I lose the case, I can then go back to see if those answers, if that line of questioning had any impact on the ultimate decision or the ultimate outcome. And if I think it did, then it might be grounds for an appeal, and it might be grounds to overturn the verdict. So even if the judge goes ahead and tries to take over my function when cross-examining a witness, the only thing I can really do is make an objection on the record, let the judge know that I disagree with his line of questioning, let the jury know that I don't think this is fair or appropriate, but the reality is the judge is going to go ahead, ask those questions, get the answers from the witness, and at some point will turn the questioning back over to me. So why do I share this great information with you? I share it with you because this does happen from time to time. And the reality is there's very little that I, as the trial attorney, can do to stop the judge from questioning the witness. You know, I realize you're watching this because you probably have questions of your own. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. I do this every single day and I welcome your call. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, @oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.